Hello, everyone. So, we will begin with marriage and divorce. Marriage means a social and legal union. Why social? Because it is a socially recognized relationship between a man and a woman. Generally, intersex marriages ही होती हैं. Why social? Because it is recognized in the whole society and it is a valid form of union in the eyes of law. We say no, officially and legally married couple. So as per law, whatever customs or traditions are prevalent according to the religion to which the person belongs, okay, those are only the personal laws. And as per following those customs, like in Hindu marriages, seven feras around the sacred fire is an essential custom without which marriage is not said to be completed in the eyes of law. Okay, so if that ceremony is not conducted, that means in the eyes of law the two people cannot be said to be married. So and after that ceremony society recognizes them to be married, so it is a social recognition as well. Through this institution the spouses create kinship. Kinship means family begins. Whatever relations are formed, that are through the foundation, through the formation of marriage only, right? A female or male partners, they both get different set of relations. जो भी लड़की के family relatives होंगे, they develop a relation with the groom and vice versa, isn't it? So the whole cycle of kinship, that is a new set of family, is created. That's why normally we say that it is not the union of only two people but also two families that those two people have carried on. Kinship is a system of social organization between people who are related by blood, marriage, or adoption. And here, whatever kinship is being created, that is created through marriage. And the groom or the bride, whosoever relatives with whom they are connected, that may be their blood relations, right? So kinship is a social organization, means in the society it is created, it is a social unit and family structure. Marriage is a social union because both spouses are entitled to each other company and conjugal rights which are mutual. That means the husband has the right to claim conjugal relation from the wife and the wife has the same from her husband. So it is mutual, and the privileges between two individuals that arise from the state of being married. So whatever rights or obligations or privileges arise from the marital relationship, that exist as soon as the two people are said to be married. First of all, it is said no that you need someone's support or you need someone with whom you will spend the rest of your life, right? So each other's company, the emotional bond, I think I've explained in one of the last videos of this chapter as well, that marriage is the way by which you have a person who will be standing by your thick and thins, right? Even if he does or not in actual, but you expect that from the person with whom you are going to get married, right? You expect the emotional bond, the social status, a dignified and a happy life with him or her, right? And the company and the mutual rights or obligations. Now there are some duties also that you need to perform as a husband or as a wife, and in the society the status that you gain is I am the husband of this or I am the wife of this, right? So that is a societal or social status of being married. These rights privileges include affection, companionship, cohabitation. Companionship means to be the companion of the other person. Affection, I think you know. Cohabitation means to live together. Property rights are also joint. What like जो भी husband का है वो wife का हो जाता है, right? और जो wife का है वो husband का हो जाता है. What is the exception of this? Stridhan. Stridhan is only and only always of the wife. Husband cannot claim rights on that. And sexual relations. If either of the spouses detaches himself or herself from the social and emotional companionship of his or her spouse without reasonable cause. Reasonable cause means without any valid reason, which can be said that, I give you an example, that because of a job transfer which has been done along with the promotion, I am forced to live in a different city, or any wife is supposed to live in a different city, then that can be a valid reason. But without saying anything, and you are not coming to meet your spouse, you have left the matrimonial home or wherever the couple was living, and without explaining anything, just I don't want to live with you, only you have said this. So that is a, now what is the reason behind it? You are thinking that you will not be able to adjust with that person, or your qualities or your conditions or whatever your way of living is, that is not matching. You're not able to draw a compatibility with the person. So whatever the reason is, it has to be fair, rational, just, and which from the face of it or from the surrounding circumstances taken as a whole appear to be a valid cause of living separately from the spouse. If there is a valid cause, then it is fine. If it is not a valid cause, that means without reasonable excuse or cause, then whosoever has been left, जो छोड़ कर गया, उस वो नहीं, aggrieved party means whosoever has been left behind in that home alone, जिसको छोड़कर वो गया है without reasonable cause, such person can approach the court for relief, and this is RCR, that you restitute the conjugal rights. These are my conjugal rights. What are the conjugal rights? Social, emotional companionship. It is a right that the person lives with me, cohabitates with me, or give me the support, give me his companionship, and he has violated that without reasonable excuse. Then I am filing for RCR in the court, which says that the court may examine that what is the reason. If it is found without reasonable cause he has left the spouse, then he may be ordered to restitute the conjugal rights of the person who is the aggrieved here. Aggrieved party can be either husband or wife. In such cases, court may direct the accused spouse, means who has left, to return to the other spouse to their matrimonial home, which is called as restitution of conjugal rights. As I have told you, restitution means to restore. Conjugal means to live together. Here it was given what all are conjugal rights. Okay. If one of the spouse has detached himself, that means he is being deprived of affection, companionship, cohabitation, or maybe sexual relations as well. Right. So, and if it is without reasonable cause, then you can claim that these conjugal rights should be restored. Fine. Marriage is a legal union as certain legal consequences follow. For example, as I told you, parties get the status of husband and wife, and whosoever children is taking birth out of that relationship, they also are said to be the legitimate child. And if they are the legitimate child, then they can inherit the property of their parents, right? And the other things which follow. It confers right of maintenance also to the wife. If it is a legally married wife, then only she can claim maintenance. Or nowadays husbands can also claim maintenance, but that is in very few or rare cases that a husband is allowed to seek maintenance from wife, because the general principle is the other way round. And inheritance of property on husband and wife. Husband, now you have to find in which section of succession act husband can get the property of wife, or wife can claim the share of husband in the joint family, right? So there is the inheritance of property as well. Majority of marriages are based on monogamy. Mono means one, gamy means marriage, so union between one woman and one man. Some society have allowed polygamous marriages. Poly means many, which is generally referred to multiple spouses, multiple marriages that include either multiple husbands or multiple wives. Now, if there is multiple husbands, generally the term is polyandry. Okay, see over here it is written polyandry, multiple husbands, polygamy, multiple wives, and these both general term can be polygamy. Okay. Generally, system is of monogamy, but some societies they also follow polygamous marriages. Whether monogamous or polygamous, marriage system does not emerge in vacuum. These different forms serve a purpose, means they don't exist without any purpose. Practice of polygamy was often a strategy for increasing the population size, because as many wives they will bear as many children, right? So the population size or demography will change. Demography. Fine. HY. This is HY. Practice of polyand. It ensured that all women in society were taken care of when men were in short numbers. So men were in short numbers. They may have different multiple wives. So they will be taking care of all the women. Similarly, polyandry is associated with shortage of women due to female infanticide and poverty. So women are less, so they will have multiple husbands so that each man has a wife. Whatever concept. Most societies also define marriage rules with respect to endogamy and exogamy. Endogamy means marriage to a person within one's own group. Endo means inside, apne andar hi. So whatever my community or my caste or my religion is, marriage within that religion. It's just an example. For example, Brahmin marries Brahmin, Kshatriya marries Kshatriya, and so on. Class, social categories like SC है तो SC से ही होगी, ST है तो ST से होगी, judge है तो judge से होगी, that may be based on the educational status. Ethnic group, based on common culture or nationality, or a religious group or a village. Exogamy means an individual marries outside the tribe, family, clan, or other social unit. It is especially with regard to descent groups on the basis of descent from a common ancestor. Means descent means the generations. So like children of same father or mother, grandchildren of same grandfather or mother, that means these people cannot marry with each other or inside the tribe. They have to marry outside, with a person who is outside his tribe. Like a sister cannot marry brother in Indian culture or in Hindu culture, to be precise, right? So grandfather के बच्चे आपस में मैरी नहीं कर सकते. सो इन हिंदूज, इफ यू स्टडी हिंदू लॉ लेटर, देन सर्टेन डिग्री ऑफ प्रोहिबिटेड रिलेशनशिप और डिस्टेंस एग्जिट्स इन विच certain degrees or generations cannot marry with each other. Okay, like basically in North India, actually sister cannot marry brother, right? Or a cousin sister can also not marry a cousin brother. That may be due to the children of same grandfather or same mother, right? So these prohibited relationships means these are prohibited. You cannot do this. If you do, that will be an incest and will not be valid in the eyes of law. Incest spelling is, you don't need to go much in detail about these, but since I've used the terms for giving examples, so I have just written the word. Okay, exogamy, certain degree of social or relationship distance must exist. That you cannot marry this generation or this person in your own clan, in your own family. Exogamic taboo is attached to marriages that take place within close relationship. That taboo is attached and it is not considered to be valid by society or by law. Different laws of marriage govern people belonging to different religions, and these you know. Now, conditions of a valid marriage. For a valid marriage, certain conditions are to be fulfilled. These conditions may vary from religion to religion, because marriage is a family law matter which is governed by the personal law or the religion to which the person belongs. So whatever conditions or customs are, that vary from place to place or religion to religion, or even in the same religion from community to community. Firstly, there is a rule of monogamy among Hindus, Parsis and Christians. They can marry only once. Their first marriage must be dissolved if they want to marry again. Only once का मतलब ये नहीं है कि एक ही शादी करे. Now if they want to marry again after divorce or after the spouse has died, they cannot marry, because the rule is they can marry only once. No. The thing is that the first marriage should be dissolved. That is a condition. If you want to marry again, the first marriage should be dissolved either by the divorce, or the spouse has died. The dissolution of marriage can take place by divorce or death. However, Muslim law permits limited polygamy where Muslim man can have four wives. So that is also polygamy for a man, not for the woman, which is allowed. Secondly, no religious ceremony is required to constitute a valid marriage under Muslim law. Offer and acceptance to marry is often required of a Muslim couple. But this is not so among the other religious groups like Hindus, Parsis, Christians. That means Muslim marriage is actually a social contract, okay, which means that the groom's family or the bride's family will give an offer that I want my daughter to be married off to your son. So that is an offer, and the other party, if accepts, that is his acceptance. Or it can be the vice versa also, like groom's family or groom's father ask that I want my son to be married off to your daughter. So either ways it can go, and the other party has to give acceptance to that. And then even when the nikah ceremony is conducted, you may have seen in TV serials or films, the two parties, groom and bride, they say kabul hai, right? So that is a form of consent which those two parties are given, right? But such is not the case of the other three religions. They do not have to signify or assert their consent to the relationship or to the marriage, right? If any Hindu marriage has been solemnized without performance of customary rites or ceremonies prevailing in the communities, then the marriage is void. So in Hindu marriage, you have to perform the customs or traditions or the ceremonies which are prevalent in that community or tribe. Okay? And those customs, since they have taken the shape and status of a law, so they are important to be followed. And if you are not following them, then that marriage would not be said to be legally valid. Hindus follow the ceremony of Saptapadi, that means 7 feras around the sacred fire. Sikhs solemnize by Anand Karach, that means 4 hymns of love are performed during the 4 nuptial rounds. That is also a kind of fera, but not in the presence of a sacred fire, but around the Gurudwara. Lavan, that is. Parsi marriage must be solemnized in accordance with a ceremony called Ashirvad, which binds the couple in matrimony spiritually. Both bride and groom promise to remain faithful to each other and to not let astray by any external temptations. For Christians in India, certain people are recognized as authorities who can perform the marriage, else the marriage is void. So, under Christian law, certain people are recognized as authorities who are conferred with the power to perform the marriages. So, they will only conduct, and if they haven't, then your marriage is not valid. These include persons who have received episcopal ordination, installation by authority, any clergyman of the church, any minister of religion licensed under this act to solemnize marriages. Minister means priest. Such persons grant marriage certificate to the couples. And when certificate is issued, that means it is declared that such and such person is married. Thirdly, different religions prescribe different age for marriage. Hindu, Christian, Parsi law prescribe age of 18 years for girls, 21 for boys, and Muslim law mentions the age of puberty, which is generally attained at 15 years of age for both girls and boys. Puberty is the age limit. Fourthly, a person cannot marry anyone who belongs to his or her close relations. Such should not be within the prohibited degrees of consanguinity, means certain blood relations or affinity. Okay? For example, a person cannot marry his or her brother or sister. Lastly, person should be of sound mind at the time of marriage. Sound mind means the ability of individuals to differentiate between what is right, what is wrong, what is good or bad for himself, or he is capable of taking his decisions by understanding that what all are the situations and how will that situation affect himself or herself, so he can take a valid decision for his betterment. Okay, and he's also able to understand the nature of marriages and the responsibilities that may arise from that relationship. That means a man who is getting married should know that what will be the responsibilities arising of that relationship towards his wife, and vice versa also. And if the person is of not of sound mind, तो maybe कि उसको ये समझ में ना आए, even if the person is making him understand, him or her understand, तब भी, क्योंकि उसको वैसे बाउट्स आते हैं या उसका माइंड उतना डेवलप नहीं हुआ है, he will not be able to undertake or withhold those responsibilities, so it's of no use. Now this is the table. You can very short form में सब लिखा हुआ है, तो you can see. Now one thing more, consideration in Muslim marriages, you can see meher or dower is provided by the husband to the wife. Okay, and it is a form of gift to the wife for giving acceptance to the marriage, and in return wife has to perform the duties, or he or she has to follow whatever the husband asks her for. Fine. So that is the two ways. Consideration goes two ways in a contract. So the same thing is over here. Then we come on to void and voidable marriages. When all the conditions prescribed by personal laws are fulfilled and there is no legal impediment, means obstacle, the marriage is considered to be valid. A party may contravene any of the above mentioned conditions, means he may not follow any of the above conditions. Then if the conditions are not followed, that means marriage is either void or voidable. Void means it is not valid in the eyes of law. जब से हुआ तब से ही वैलिड नहीं है, और हम ऐसा मानेंगे कि वो कभी एग्जिस्ट ही नहीं करी. इट वॉज नेवर वैलिड इन द आइज ऑफ लॉ, एंड इफ इट इज़ नॉट वैलिड इन द आइज ऑफ लॉ, देन उसके एग्जिस्टेंस ना एग्जिस्टेंस से कोई मतलब नहीं है. इन द लॉ इट इज़ डीम्ड नॉन एग्जिस्टेंट. चाहे आप अभी उसको चला रहे हो, बट क्योंकि लॉ उसको नॉन एग्जिस्टेंट मानता है, तो आपकी मैरिज का कोई वैल्यू नहीं है, इवन इफ द कपल कंटिन्यूज टू लिव इन दैट रिलेशनशिप. They will not be considered to be a legally married couple. Voidable means, if you break down this term, void plus able, that means which is able to be declared as void. So that can be done at the option of the party who is aggrieved. Suppose कोई child marriage हुई, means a girl below the age of 18 years is married off to a boy whose age is 25 years. Now, at the option of this girl, when she attains majority, she can declare this marriage to be voidable. So, she will declare it to be a void marriage, but at a later stage. So, this is a voidable marriage which can be declared as void at the option of this party. So, you can break down this term wherever this voidable comes. In such case, dependent upon the nature of conditions so violated. So it is a void or voidable marriage is dependent upon the conditions which are violated. For suppose, generally, child marriage is void ab initio. Means from the very beginning it is considered to be void. Both the parties are of 5 years or 10 years. Female is of 5 years, male is of 10 years. So it is a child marriage, right? Void ab initio. So nature of the conditions violated shows whether it will be a void or valid marriage. Voidable marriage is perfectly valid as long as it is not set aside by any court of law. The aggrieved party can file the petition for annulment. Court can annul by passing a degree of nullity. Annul means to declare it null and void. Okay, so it will be valid. Voidable means it is capable of being declared void or set aside or not a valid marriage as per law, but in a future date, और तब तक वो valid रहेगी. ठीक है, तब तक it is valid. If suppose in the earlier example that I gave you, that 16-year-old girl does not file any petition in the court for declaring her marriage avoidable or to set aside, तो क्या होगा? कंटिन्यू करेगी, एंड शी विल बी द वाइफ, and it will be said to be a valid marriage. So it depends. That's why it is set at the option of the aggrieved party. He or she can file the case and get the marriage declared to be null and void. And since it is a decree which is declaring a marriage to be null, so it is a decree of nullity. A void marriage is no marriage. Word marriage describes that two persons have undergone the ceremonies. The ceremonies are a prerequisite, means these are the essential condition without which a marriage cannot be said to be completed. And if it is not completed, then it is not a valid relationship in the eyes of law or even society. So these, again a flow chart you can see. As I told you, in void, you can see it is written, marriage never existed in the eyes of law. So even if the couple continues to live as they were living, तब भी हम नहीं मानेंगे कि वो लीगली मैरिड हैं, भले ही वो जो कुछ भी करे. बट हमें पता है, और लॉ को और सोसाइटी को पता है, दैट इट इज नॉट अ वैलिड रिलेशनशिप. Hindu Marriage Act makes the distinction between void and voidable marriages. 3 grounds for void marriage. First, marriage with any person falling within Sapinda relationship. Lineal descendant. Descendant means the other following generations. Linear means in a line, right? Third generation in the line of ascent means आगे वाला, through mother. Mother का ascent क्या होगा? Third generation, mother, son, son, son. इसका son ये, इसका son ये, right? ऐसे पढ़ा होगा आपने कभी ना कभी तो. So this is the third generation. This is prohibited. Then father, 5th generation. Right? Including the person whose relationship is being tested. Suppose this person is tested, so he has to be included in that 5 generation which you are being calculated. Okay? You will study more in Hindu law when you will study that in detail. For now, just remember that ऐसे ये 3 generations बनाए जाते हैं और इसको सपिंदा या prohibited relation बोलते हैं, जिसके अंदर marriage नहीं हो सकती. Okay, and these are all what? This person is connected by blood. This person, if the son of S2 is the son of S1, then of course it is a blood relationship, right? So in blood relationships of 3 degrees and 5 degrees, marriages cannot take place. Degrees is what? The line of ascent that I am telling you. Okay, for suppose a person cannot marry his maternal or paternal uncle's daughter. Maternal uncle कौन होंगे? मामा. पैटर्नल अंकल कौन होंगे? चाचा या ताऊजी, राइट? सो उनकी बेटी से भी शादी नहीं हो सकती है. द एग्जाम्पल ऑफ विच आई गेव यू अर्लियर, दैट अ कजन सिस्टर और कजन ब्रदर who may be connected by relationship of children of same grandfather, right? They can also not marry each other. ये बोला था अभी मैंने कुछ few minutes पहले ही ये example दिया था. So that is under this sapinda or prohibited relationship. Prohibited means it is not valid. इस पर बार लगाया गया है. So such marriages can also not be conducted. But as a matter of fact or tradition, whatever you may say, ये जो मामा और भांजी की शादी हो सकती है. And this tradition is valid in southern part of India. Even in Hindus it is valid, right? So that is again a custom or tradition which is prevalent, and custom, since it is followed since many years, it has gained the status of a law. So that may be considered in the eyes of law from that perspective. Okay. Second, one cannot marry with any person falling within the ambit of prohibited relationship. For example, no marriage between uncle and niece or aunt and nephew. बुआ भतीजा या मामा भांजी, इन सब के बीच की शादी नहीं हो सकती. The concept of prohibited relationship is wider as it covers relationship by blood and marriage. Lastly, if any Hindu remarries during the lifetime of his or her spouse, then the second marriage is void. So if the spouse is living and in spite of that the person has remarried, since first one was valid, no, the second one will be void. will be invalid from the very beginning. We will consider it to be non existent in the eyes of law. That is void. Four grounds for voidable marriages: if marriage cannot be consummated due to impotency of one spouse, then other spouse can get it annulled. Impotency does not mean barrenness or sterility, means inability to have child. Rather, it is failure to have sexual intercourse because of some medical or biological issue or infirmity. The person is not able to have sexual intercourse with the spouse, then the marriage can be annulled at the option of the aggrieved party, right? And that is impotency, which does not include barrenness or sterility, inability to have child. Okay, that means inability to bear a child in the womb. तो सिर्फ इस बेसिस पर आप उसको, that inability can be on part of husband and wife both, fine, but it only means मेडिकल ग्राउंड्स के रीज़न की वजह से कुछ इनएबिलिटी टू हैव द सेक्शुअल इंटरकोर्स. Secondly, consent for marriage is obtained by force or fraud. Then the aggrieved party can get the marriage annulled. By force or fraud means photo किसी की दिखाई, that is an example of fraud which I am giving you. I have shown the photograph of a girl A, but the person B is getting married to the girl named C. So what is this? Fraud. That I have shown you something, but I am getting you married off with some other person. Okay? Or I have by force, that I am beating you day and night, or I have kept a gunpoint on your head that you have to get married today itself with this person, otherwise I will kill you. So that is at gunpoint, that is force, and by fear you are having that relationship. सो द अग्रीव्ड पार्टी, जिसको गन पॉइंट पे रखा गया या जिसको गलत फोटो दिखा के गलत इंसान से शादी करा दी, दैट इज द अग्रीव्ड पार्टी, राइट? ही और शी कैन गेट द मैरिज annulled. Thirdly, when the pre-marriage pregnancy, pre-marriage means marriage होने के पहले the wife was pregnant. That means maybe the child is not of the person with whom she is getting married right now. Okay? When the wife is pregnant before marriage by some person other than the husband is another ground, but husband must be ignorant of this fact at the time of marriage. Means he was not having any knowledge of the fact that my wife is pregnant and she is bearing the child of some other man. अगर उसे पता है और ये जानने के बाद भी उसने शादी करी, that may form a part of implied consent by husband. But if he has no knowledge whatsoever of the fact, then उसको पता ही नहीं है कि वो pregnant है. अगर even if, lastly, unsoundness is also a ground. Unsound है, I cannot live with that person, भाई नहीं हो पा रहा adjustment, so that can be the ground. Muslim law, void marriage is known as partal marriage. The term nullity is applicable to void marriage as marriage does not exist from the very beginning and court merely pass a declaration as to its nullity. क्योंकि हम मानते हैं कि वो marriage void मतलब it was never valid, it is non-existent in the eyes of law. So अभी हम जो कोर्ट से declaration पास करवा रहे हैं, like in the case of second marriage of Hindus when the spouse is living, तो वो सिर्फ उसकी नलिटी को डिक्लेयर कर रही है. इट इज ऑलरेडी नल एंड वॉइड, एवरीबडी नोज दैट, बट टू डिक्लेयर इट बाय अ फॉर्म ऑफ सर्टिफिकेट, दैट इज अ डिक्री ऑफ नलिटी which is passed by the court. So court only declares it to be null and void so that it comes in the notice of everybody, of the whole public, that okay, this is non-existent also socially. But as per law तो वो शुरू से ही मानी ही नहीं गई कि वो शादी कभी हुई भी है. ठीक? There is no concept of voidable marriage under Muslim law. Rather, they recognize concept of irregular or fasid marriages. Irregular marriage is that which can become valid if the defect is cured. Irregular means something which is not regular or there is a defect. अगर regular होती तो कोई defect नहीं होता. So when that defect is cured, again irregular will get converted into a regular marriage. For example, marriage with fifth wife is irregular. But if any of the earlier four wives dies or the marriage with any of the four wives is dissolved, by divorce. तो क्या होगा, अब वो फिफ्थ वाइफ 4 के एम्बिट में आ जाएगी and that would be a regular marriage. Irregular marriages are recognized only by Sunnis and not Shia sect among Muslims. As you know, there are two sects among Muslims, Shias and Sunnis. So only Sunnis recognize this form of fasid marriages and not Shia sect. Concept of void marriage is recognized under Muslim law. Marriage is void on grounds of polyandry, means a wife having multiple husbands, because that is not allowed in Muslims. Consanguinity, affinity, and fosterage. Consanguinity means the blood relations, okay, and fosterage means under Muslim law, when a child of 2 years is breastfed by a woman who is not his or her biological mother. ठीक है, तो अगर ऐसे women से वो शादी करता है, that will be void. Polyandry means married women cannot contract a second marriage during subsistence of first marriage. Consanguinity means prohibition of marrying certain blood relations. For example, Muslim cannot marry his mother, grandmother, daughter, granddaughter, paternal and maternal uncles. Affinity means prohibition of marrying certain persons with whom relationship has arisen by marriage. For example, a Muslim cannot marry wife's mother or grandmother, daughter or granddaughter from another husband if his marriage with wife is consummated. ठीक है, so consanguinity means relationship through blood and affinity relationship through marriage. Fosterage means when a woman other than mother of child has suckled a child under the age of 2 years, woman becomes the foster mother and he cannot marry his foster mother or daughter or sister. Christian law, Indian Divorce Act, governs Christians. It provides for nullity of marriage but does not distinguish between void and voidable marriages. It only states that marriage may be declared as null and void on certain grounds. What are those grounds? That aggrieved party can get the decree of nullity on ground of impotency of other spouse at the time of marriage. So at the time of marriage, if it is discovered that this person is impotent, okay, then if parties are within the prohibited degrees of consanguinity or affinity, or if the former husband or wife was living at the time of marriage. Since in Christians also there is the concept of monogamy. And it may be annulled if either party was of unsound mind at the time of marriage. So this is an essential change at the time of marriage, for impotency and unsoundness of mind. Then since monogamous is allowed, and then prohibited degrees of consanguinity or affinity. More or less same grounds hai. Parsi law do not recognize distinction between void and voidable marriage. Under the Parsi Marriage and Divorce Act 1936, declaration as to nullity can be obtained in one situation. Only one situation, that is consummation of marriage is impossible due to natural causes. And what can be the natural cause? Some biological or medical inability or infirmity in the person. Okay? कि consummation नहीं हो पा रहा है, inability to have sexual relations, right? Then divorce, the next video.